Okay, so the yin to the prosecuting attorney's yang is the defense attorney. This is the counterpart of the prosecuting attorney. The role of the criminal defense attorney is, as an officer of the court, they're required to uphold the integrity of the legal process. Defense uses all means at its disposal to refute the state's case. And it takes an adversarial procedure where the process of publicly pitting the prosecutor and the defense against one another in the pursuit of truth is the driving force of the legal system itself. It's the Sixth Amendment that allows for the provision of counsel at trial, but does not address what to do for a criminal defendant who cannot afford an attorney. Gideon versus Wainwright, the U.S. With this ruling, the U.S. Supreme Court took a major step, its first major step, on the issue of rights to counsel by holding that state courts must provide counsel to indigent defendants in felony prosecutions. Argersinger versus Hamlin, in this case, the court extended the obligation to provide counsel to all criminal cases where the penalty includes imprisonment, both felonies and misdemeanors. Many other cases have required states to provide counsel for indigent defendants at all stages of the process. The Sixth Amendment right to counsel and the Fifth and 14th Amendments guarantee of due process of law are interpreted together to provide defendants with counsel. Areas of the criminal justice system which remain a place for courts which are not required to provide assistance of counsel. This includes pre-indictment lineups, booking procedures, grand jury investigations, appeals beyond the first review, disciplinary proceedings in correctional institutions, and of course revocation hearings after the release. The defense attorney is, of course, providing legal services to indigent people. There are three major categories of public defenders. There's the public defender, which is a salaried staff of full-time or part-time attorneys. There's assigned counsel, which is a lawyer appointed by the court to represent a defendant. And then there's the contract system, which provides counsel to indigent offenders by having attorneys under contract to handle such cases. Then there's the private bar, where some defendants hire attorneys at their own personal expense. Attorneys may specialize in criminal law or take cases as part of their general practice. Some are well known for highly publicized cases, but this is probably a pretty limited group, and a large number of defendants represented by a lawyer who accepts many cases, and they usually take small fees. That leads us to the question of, does the type of lawyer matter? Well, conviction rates for indigent defendants and for those with their own lawyers are about the same in federal and state courts. About 90% of federal defendants and 75% of defendants in most populous counties were found guilty, regardless of the lawyer. Those represented by publicly financed attorneys are incarcerated at a higher rate than those who pay for their own counsel. And sentence lengths for defendants are shorter with publicly financed attorneys than for hired counsel. In large state courts, defendants with publicly financed attorneys sentenced to average of 2.5 years, and for those private attorneys to 3 years. So, maybe it's not that smart getting your own attorney. Maybe a public defender is going to be a better option for you. That brings us, of course, to the question of how competent are defense attorneys? Well, as it is with any attorney, attorney competence can be a serious problem. We find in Strickland versus Washington, a process was created for determining the effectiveness of counsel. First, the defendant must show that the counsel's performance was deficient and that such serious errors eliminated the guarantee of counsel under the Sixth Amendment. And second, the defendant must also show that the deficient performance prejudiced the case to such an extent that the defendant was deprived of a fair trial. After this, we would decide whether counsel is ineffective and then what to do in the next step. The last section of the court that we want to look at is the court administration. The court administrators are trying to serve the need of providing a more efficient management of the judiciary system. Their goals include improving organization and schedule of cases, allocating court resources efficiently, and preparing budgets and overseeing personnel. They were created in 1939 with the Administrative Office of the United States Courts, and states have experienced slow and uneven growth in this area, but today all employ some form of central administration. The court administrators, of course, use technology in court management. That technology is in reference to communications, video conferencing, evidence presentation, case management, internet utilization, and information sharing.